Ready when you are.
Good afternoon, Your Honors. May it please the court. My name is Michael Clark, and along with my colleague Jennifer Emerson, we represent Progressive Select Insurance Company. I'd like to reserve 5 minutes for rebuttal. The relief we're requesting here from the court today is to reverse an order denying attorney's fees to Progressive Select under a proposal for settlement, with the trial court concluding that it had not been made in good faith.
So the one summary judgment based on the MRI case, and then the judge found it was in bad faith based on the great public awards and the Supreme Court taking jurisdiction over the same case.
Yes, Your Honor. It is somewhat incongruous. And the basis as expressed was that there was an unsettled, the argument that was advanced by the opposition, when there's an quote unsettled status of law, therefore it would not have made in space. But the language of both the final judgment granting Progressive its motion for summary judgment was based upon this court's opinion as authored by yourself with your colleagues in the MRI Associates case. And then in denying the rehearing of that final judgment, the trial court indicated that it was bound to follow the Tampa MRI Associates case. I included within my appendix the jurisdictional order from the Florida Supreme Court. They found that they're not going to decide the case, at least on the basis of any conflict jurisdiction. They may review the issue of great public importance that's there. They also may not do anything. They may discharge the writ.
The trial court's ruling is subject to an abuse of discretion.
It is indeed, sir.
Is it possible that the court, on the merits of the claim, felt bound by the case, but recognizing that it is an issue that the Supremes may weigh in on, thought $50 offer of judgment just didn't cut it?
Well, but I think the test is, was there a reasonable foundation to make the offer at the time, or I'm sorry, the proposal at the time that it was made? And the facts show that the law in the state of Florida had clearly established, not only through the orthopedic specialist case opinion, your opinion in Markley Chiropractic, the opinion that you authored, and by the time, again, Tampa MRI Associates decided before the service of the proposal, that's the reasonable foundation. We can't have any uniform jurisprudence in our state if we are allowing trial courts or other courts of inferior jurisdiction to ignore binding precedent. And that's what this is.
But it can be, if the court was required to follow binding precedent, ipso facto, there was no possible wiggle room on whether your claim would have any weakness that would suggest that you should have, in good faith, tried to dispose of the litigation, as opposed to a conclusion that you just, all you're trying to do is get paid. In other words, that's the other extreme that you're kind of proposing. Like, well, hey, the court said I was bound, so therefore we obviously had a rock solid case that permitted us in good faith to say we'll give you nothing, pretty much.
Well, now you're
That can also be the rule.
well, I'm sorry, you said that can't.
That's the other polarity. It sounds like you're suggesting.
No, what I'm suggesting is the entire purpose of the proposal for settlement statute is to make people take a very close look at their case before they continue litigation.
And the trial court thought, well, you didn't take a good look at your case, because even though
Trial court thought the plaintiff didn't take a good look at their case. Because again, let's look at the facts of the procedural posture of the case before the proposal was made. The complaint.
well, wait, maybe I'm twisted around here, but you're saying this, the trial court thought that if the proposal wasn't in good faith, which leads me to believe the trial court thought the one making the offer of judgment had not taken a look at its case.
Yes, I agree with that statement. Yes, based upon Wagner versus Brandenberry, the trial court concluded that there was no reasonable basis for the offer that was made. Yes, so you were, I'm
So
sorry.
my point was that you're saying, it sounds like what you're saying is that, well, since the trial court ultimately decided that it was bound by case law, that must mean that the offeror's case was absolutely rock solid, such that it could never be, no aspersions could be cast on good faith if they offered essentially nothing.
No aspersions can be cast upon the idea that there was a reasonable foundation to make a nominal offer. Because nominal offers are made all the time.
So
Assessments
anytime,
of liability.
but that's just saying, anytime you win,
No,
we can make a nominal offer and it's in good faith.
no, it has to be, it
Why
has
do
to
you usually win? You usually win because the law's on your side. So
Mhm.
because the law was on our side, therefore we had a good basis, therefore we had good faith, therefore nominal offer meets the good faith standard.
we're skipping a step.
Okay.
We're skipping the step of what is the basis of that reasonable foundation to allow the nominal.
Well, let's get it.
Okay,
Say, why was your notice ironclad under?
I'm happy to answer that question. The complaint was filed in April of 2018, very clearly a breach of contract for payment, underpayment of PIP benefits. Crystal clear, the issue is, should they have paid at 80% of the amount charged, or should they have paid according to the schedule of maximum charges? The answer was filed with a very clear affirmative defense saying that we've done everything that we've needed to do. Our policy has provided sufficient notice. These are things that have occurred before the proposal has been served. Then we serve our motion for summary judgment. Single issue of dispositive law, matter of law only, interpretation of the statute and the policy. And we support that by an affidavit that establishes that this is the policy that was in effect and supplies a payout sheet, which shows what we paid, how we paid it, and paid it according to the schedule of maximum charges. Still, no proposal of settlement served. So at this point, we've now have the complaint at issue. We have the motion for summary judgment filed, and we have a supporting affidavit that authenticates the policy as well as the payment methodology that was at issue. We go so far as to begin to rely upon the Allstate, the orthopedic specialist case and identify that. By that time, this court had decided both Tampa MRI and had decided MRI Associates and had decided Markley Chiropractic. So those things are out there as binding issues of law. Then we serve the proposal for settlement. And that the examples that I used in the brief, and I will go to them right now, they occur all the time in contractual obligations when you feel that you have no exposure under the contract, which is what the position that we were taking. And I cited two cases for.
What is this? And yes, I follow you. I'm just curious. Is there room for the idea in all of this that if I know you cited it, ample authority that nominal offers are not per se bad faith. But is there any room for the thinking that, well, even if you think that you have absolutely positively no liability on the current case law, that if you don't even make a good faith effort to try to support the baby, then all you're really doing is setting yourself up for these.
That's not what the statute is designed to do. The statute is designed to terminate litigation. That's what Progressive wanted to do here.
The other purpose is to say, I want to let you know that you have no case. And if you proceed further, you're going to be liable.
Progressive laid all their cards on the table at the very inception of this lawsuit, before they filed the proposal based upon an application of binding authority. Had they
So the
accepted,
standard is not whether you were really, so I mean, in this case law, there's talk about the public policy underlying the statute and what is the public policy. What you're saying is, also what the case law says is that good faith is merely an assessment of whether there's a basis for your offer and whether it has any relation to what the strength of your case and the relativity.
That's what this court has said specifically in Wagner versus Bradner. And it's part of the whole, and again, let's make no mistake here. The provider or the appellee had the ability to accept a nominal offer and run no risk of an attorney's fee. Okay, so this is not getting, Progressive is not interested
Or
in
voluntarily dismissed.
or voluntarily dismissed, or even before the summary judgment hearing, which occurred in January of 2019, months after, they still could have stayed out from the threat or the specter of an attorney's fee award by dismissing the case, as you've indicated. And by then, the law was so favorable to Progressive's position on the facts, and recall the record will show, there was no opposition to the motion for summary judgment at all.
Well, let's pivot to discretion, which the abuse of discretion standard is so wrong. We have to find that no other judge, no other trial judge would have done this. Agree with that?
No, yes, I
No
do.
other reason wrong.
Yeah.
But if you look at 7A, 769, 7A, and 7B. So 7B, I get it's triggered when you determine entitlement. And then that's mandatory, which you gotta consider. But if 7A says it's up to the judge's discretion to determine whether it's made in good faith, what precludes the judge from going down and looking at 1 through 3, but also their case law says the judge can look at strategy, status of the law, whether the offeree or the offeror will waiver from his or her strategy, can assess the logic and strategy in the case, whether there's a reasonable foundation. Then there was another case where the offeror took the depositions of certain witnesses and found the case had no merit whatsoever. So the trial judge can consider all of that in determining under 7A whether it's made in good faith. Why can't he or she determine under 7B 1, 2, 3? I understand it seems incongruous, like you said, but the Supreme Court had accepted jurisdiction on Tampa and Ohio. And this particular judge, believe Judge George, that the unsettled nature of the case. I mean, is that abuse of discretion? Consider that a judge abused discretion because he ignored the fact that the Supreme Court took it up. Question very important.
Yes, it is an abuse of
And they could
discretion, especially for the reasons that he expressed in denying the motion. That there was little and no discovery, which was completely irrelevant to this case. There was no discovery that was at issue, or
I think that both ways.
and then secondarily, that the binding or unsettled effect of the law. But the fact of the matter is, Your Honor, I certainly am not educating this court. The idea of Pardo is that these cases are set. We are bound to follow them.
That goes to my other point, you know. I mean, I understand a lot of the arguments you're making, but if that was the case, I mean, we cite Pardo, everyone knows that you have to follow line of precedent. But just because of the binding, if that was into the question, we would never, there wouldn't be any discretion. Hey, you won because I had to follow the binding law that's on your side, therefore you could never have that faith. I mean, maybe I'm not making myself clear.
You could never have a reasonable foundation for making the offer. Again, there's a
Unreasonable.
or an unreasonable.
You know, because, I mean, I just want to say that part of your argument, I'm having trouble with, to say, because it was bound by binding precedent, therefore, there can be reasonable basis for the offer, not just winning, it's the offer could never be assailable.
And that was the premise of my argument, because that was the reason that the court expressed in saying that they concluded that it was not made in good faith. The fact of the matter is,
Which gets again to the dilemma of all this case law that seems to be speaking out of both sides of the court's mouth. One, is it a reasonable basis for the offer? If you have a reasonable basis, then I have no liability, then therefore that would be met. You have good faith to say I have no liability. It's the case we win. But if there is some wiggle room on what good faith means, which is to say, there are also case laws saying, well, if it can be ascertained by the trial court who has discretion that the offering party was just trying to set itself up for fees, and it really and did not take into consideration there was some doubt on the ultimate merits, then why couldn't they say, well, isn't there something more than just whether you think you have zero liability?
There is not a single case in the state of Florida that I could identify that would allow for the reasoning for this court to express its use of discretion in the manner that it did. And I can point to cases that equate the idea of granting summary judgment in a nominal offer in an insurance contract case is a good faith basis for making that nominal offer. The Citizens Property versus Perez case, that was a case where there was a nominal offer made and it was based upon an assessment that the insured did not report the alleged damage to his home for nearly 4 years after the fact. So there's a late reporting issue. And the 4th District Court of Appeal in that case reversed and said on this contractual issue, the insurer stepped back and said, we looked at our contract, we think we did the right thing, we've got a great defense, we're going to give you the opportunity to settle for this nominal amount and avoid the entire purpose of 768.79, which with no fault insurers, frankly, in the state of Florida need the benefit of, and to protect themselves from lawsuits that may not have merit, so that they can give an opportunity for the plaintiffs to make a decision about whether it's a good idea to continue to go forward. And the second case I cited in the brief on that principle is State Farm versus Laughlin Alfonso. And then that was a case with a failure to satisfy pre-suit requirements in submitting sworn proofs of loss. And the 3rd District Court said, we're going to reverse again. It is an abuse of discretion when an insurance company sits back, looks at their policy, looks at the facts and says, we're going to win this thing. And that's what Progressive did here. They sat back, they looked at the facts, they looked at the policy, they looked at the law, they said, we're going to win this thing. We're going to give you an opportunity to accept $1 for the benefits and $49 for the attorney's fees, granted a nominal amount. But the case at issue, correspondingly, somewhere around $300 allegedly were at issue. So, 50 to 300, the shoe's on the other foot, isn't it?
A way of making another argument, which is that you did split the baby.
Well, and yes, and it's also making the argument that, sometimes you shouldn't just hang on to this case hoping that you're going to win, so that 627.428 is going to result in an attorney's fee to you.
Mr. Clark, let me interrupt you. We've been peppering you. You've used about 17 minutes.
Okay, I'm going to reserve the remainder for rebuttal.
Okay, very well. Thank you. Counsel?
Good afternoon, Your Honors, Counsel. May it please the court. I just want to start off by saying it's nice to be back in the workplace again, and in front of it's an honor to be in front of you all. I don't know that I'm going to use my whole 20 minutes on this. I don't really have a whole lot to say. I think the court understands our position of abuse of discretion on this, just judged based on the questions that were going on before. I mean, that's our argument, is that.
Well, why does an offering party need to split the baby if under prevailing case law, they believe they have under prevailing case law, they have no liability? Is there a policy argument? Is there a reason on the language of 76879 where you have to try to take a few steps toward the other party's position if you think their other party's position is absolutely lacking in merit?
If they're saying the total exposure was $300 and we're here right now, why they didn't just pay that $300 and be done with it?
Well, that actually then speaks to the fact that we don't even have to determine my kind of esoteric policy question about, or I should say more philosophical policy question about whether you need to split the baby, because you're just emphasizing that they did split the baby. $50 is, I'm not very good at math, but what percentage of 300? It's pretty high percentage, 1/6. So
Right.
They did take steps towards your client. So why is that?
Well, that certainly $300 wouldn't be the whole value of the claim, right? Because there's still the attorney's fees part of it. If, we're just talking about
I'm relating to is that it's $1 for down there. All right. Well,
just dissuade me from this position that this order may have been different if the offer was more. It was $300, for.
I think that that's just a factor. The nominal nature of the offer is a factor.
Yes, Judge George made an interesting reference to conflicting opinions in this circuit, when yet he ruled in summary judgment that, you know, MRI Tampa was on point, as they used to call cow.
I
4 legs.
Yeah, totally agreed that on the face, this seems incongruous, right? That she would ultimately, and Devin George is a lady, Your Honor, just so just so Your Honor is aware that that would be confusing,
One of our first county appeals.
yeah, and again, the PIP nature and the extended jurisdiction of this court, you know, this isn't something necessarily that is the regular thing that's here, but yeah, but the offer, but what appellant is asking you guys to do is to take away the reasonable person standard, right? That no other reasonable person could have agreed with Judge George. I mean, the language is clear. Discretion is abused only where no reasonable
So it's
man.
very deferential review, but aren't there cases cited by the appellant in which, under that standard review, appellate courts have said, hey, trial court judge, you abused discretion by drawing the conclusion that this was in bad faith merely because it was nominal offer. So what distinguishes those cases in which the appellate courts have reversed based on the abuse of discretion in this case?
Well, I'll go right to Brandonberry as the one coming out of this this particular court. In that case, there wasn't a nominal offer, right? There was a substantial offer, a 6-figure settlement offer. That was done after, and it was a trial award that was ultimately done, not a motion for summary judgment. This was a jury award that ultimately came back. So discovery, that was a personal injury case. We're talking about a PIP case. You know, so they're just on Brandonberry. There are a number of distinguishing factors, I think, that suggest that the reasonable standard was that a judge can find bad faith. In the other way, there's no finding of there could never be bad
Okay,
faith.
so we know what the judge did here, though. The judge inferred. Okay, so the judge based it on the fact that the issue that some scintilla of doubt had been cast on this issue because the Supreme Court had taken up our case.
Yes,
So
MRI Associates, State Farm versus MRI.
right, so it essentially said, you can't, the judge said, well, it's ipso facto bad faith if your offer was nominal and there was some tiny fall of a doubt about whether sometime in the future the law that this court was bound to follow may be overturned.
If we look at the timing of this, our statement of claim came out. After that, MRI Associates was ruled on. Then the proposal for, the summary judgment followed after that and so forth, right? So when the case was first, I mean, this was good. And it's interesting to me that one day we've got a valid case, a real contention, right? On whether or not, the election of fee schedule was appropriate. And then the next day, our case is, completely valueless, right? That just doesn't seem.
Is that the chronology, and then thereafter the summary judgment was filed, and then thereafter there was. In other words, the chronology is these cases were known to the offeree at the time of the offer, right?
I wouldn't disagree with that. That's right. MRI Associates had
You just said one day your case had some merit, and the next day.
when we filed our statement
Right,
of
so
claims.
at the time you received the offer, it was valueless.
According to this court, I essentially I think that that's the ultimate conclusion that the trial court came up
So in
with.
other words, you said, but according to this court, your case was valueless at the time you received the offer, and we're reviewing a court exercising its discretion to say that because the Supreme Court granted review, or at least didn't outright dismiss the petition, that it's bad faith.
I think that the trial
Bad
court,
faith, when is the bad faith should be assessed, by the way? At the time, it was, when did the Supreme Court, pardon me for forgetting the procedural chronology. When did the Supreme Court grant review?
I couldn't be
Okay, so
with any type of
Before or after the offer?
after, sir, I believe.
Okay, so if that's the chronology, at the time this offer was made, you just said your case was valueless.
According to,
To the law.
right, that had just come out. That's
So
exactly
At
right.
the time the offer was made, your claim was valueless. But why does a defendant have to split the baby if at the time it makes the offer, the plaintiff's case is valueless?
Because they don't know that at the time, sir. I don't think that's absolutely knowable at that particular time. Absolutely, you know, given the record, and that's, I think we're getting away from whether or not it's reasonable that Judge George found no reasonable foundation to make this offer, meaning that you can't just rely as a defendant that a case law comes out and say, I got it in my back pocket just based on this alone.
Never rely on it.
I mean, I think it would. I mean, I think it's imprudent, right? To just take a piece of case law and then go to your client and say, it's in my back pocket, it's a done deal. Because you can't anticipate everything. Now, it wound up panning out in this case, right? I mean, but without, it's a tantamount to a bet, placing a bet and your horse coming in.
Who's making the bet? The defendant?
That's right.
Well, then isn't the plaintiff also making the bet that they're gonna somehow throw a Hail Mary and the now prevailing and binding case law is not going to defeat them?
That's, I mean,
And isn't that one of the potential or perceived purposes of the statute to illuminate the party's position so that a plaintiff can decide whether it wants to go forward and incur fees?
I think the purpose of the statute is to encourage settlement. And I think $50 is a hard way to do that. I think that's the heart of the proposal for settlement statute, right? I mean, this is plain language stuff, settlement, proposal for settlement. It's not proposal to dismiss your case, right? I mean, I totally understand the court's position that in counsel's position that it's to take a good look at it. But I mean, in this specific instance, the truncated time period with which the case law came out and the fact that there was little to no investigation aside from case law
Wasn't
coming
this
in.
based, correct me if I'm wrong, wasn't this based on language of notice and policy and then whether it was adequate under the case law? That was enough to justify election of the statutory caps?
I'm sorry, Robert,
Well-
the base statement of the claim?
Yeah,
Yes, that's right.
so what needed to be, what would have needed to be fleshed out in litigation in order for the plan to,
To see if that, I mean, and it wound up being the case here, and I don't know the specifics of the underlying, sir, but, you know, and I didn't argue that, and I'm not trying to lean on that as a crutch in any way, but
well, if I'm incorrect in the way I characterize it,
no, I think you're right. I think you're right, sir. So I mean, that's the crux of my argument, Your Honors, is that Judge George did not abuse her discretion, and that to hold otherwise is to throw the reasonable judge standard out the window, that no other judge could have found that there was bad faith in a scenario under these circumstances. In the Brandonberry case, there were specific findings on the record as to why the judge found, you know, the reasonableness on the record as to why the proposal was made, and then reversed on completely different reasons. In this case, we have the judge finding on the record why they believed it was unreasonable, even though they ultimately agreed in the end with the argument. So Judge Sleet, I totally understand the incongruous nature of kind of what I'm positing here. I totally understand that, but I just don't think that you could legitimately say that no other judge would find that there was bad faith in the making of this particular nominal offer, especially given the timing.
Very good. Thank you, sir. Clark?
Thank you, Mayor. Please support. Just to clear up a couple issues on the chronology. The Markley case was decided in 2016. Temper MRI Associates was decided in 2018, May 2018, before the proposal. The appendix shows that the Florida Supreme Court issued that order on discretionary jurisdiction on July 17th. All those things occurred before the proposal was served.
So at the time of proposal, the offeror knew that Supreme Court.
Yeah, and all that was established law at that point. Secondly, the idea that at the time that the case was filed should be evaluated from merit of other law, that there was a virtual imaging case that was decided back in 2013 that makes a very clear distinguishing about the amendment to the statute in 2012, adding 5A5, which just imposes a simple notice requirement, which changes the standard, which the provider should certainly have known about when they filed this case. The next thing on the abuse of discretion standard, which I think the court is concerned about, no reasonable judge. The fact of the matter is there's still a quantum of competent substantial evidence when you're discussing whether there is a reasonable foundation for making that nominal offer. Progressive went to the extreme measure of filing an affidavit on the rehearing after the denial of the motion, where the handling adjuster, the same affiant who supported the motion for summary judgment, explained the basis for making the offer. The only evidence that existed in the record was those statements as to why that offer was made in the manner that it did. So you have facts here that show, and case law that shows that if an insurer evaluates no exposure under a policy, nominal offers are made in good faith. And the reversals are out there, and they're in the brief. And the last thing I will say is, we're undermining the purpose of the statute if we allow for a rule of law for the trial court to, and I don't agree that the law is unsettled. The supplemental authority that I filed last week before this court and contained a case from the 4th District Court of Appeal where they relied upon MRI Associates in reaching their conclusion. The law is settled. Simple notice carries the day. And we ask that you reverse as an abuse of discretion and fulfill the purpose of the statute.
Very good. Thank you. Thank you both. That concludes our docket for this morning, this afternoon, and we are.
All right.